So welcome back to another slot for the second session. I believe it's actually the last slot for the second session. Please welcome J.Luksan and Christiane Feichter, both lawyers and associates from the law firm J.Luksan Partner in Vienna. They both advise and support startups and young companies as part of a startup initiative. It's called, I believe, Nuco Legal, correct? Exactly. They support startups in this field to really make them aware what IP issues there are, what IP mistakes there are. I mean, there's a lot of pitfalls that can be done, and then if you find out a couple of years down the road, it might really destroy your product or make your investment from the point of view of the investors unworthy. Yeah? They will have a conversation between the two, and they will talk about real cases and make a recommendation based on real examples. So, Julia and Christiane, the stage is yours.
Thanks.
Thank you. Good afternoon. Thank you very much for having us. So in the next 15 minutes, Christiane and I will try to give you a compact overview of the basics of intellectual property law. Just a heads up in the beginning, as far as legal information will be concerned, our presentation refers to common requirements within the European legal system. So we would like to start by giving an overview of what kind of IP a hardware startup needs.
Yeah, that depends on the specifics of your product and what you aim for with the protection, as every intellectual property has its own purpose. As a startup, you may want to establish your own brand and a strong corporate identity. You want people to look at your website or products and immediately associate them with your company. Therefore, you will need a strong trademark, which serves as a so-called indication of origin. You can protect signs that are suitable to distinguish the goods and services of your company from those of others. The usual trademark may be your company name, your logo, or even sounds that is a distinguished part of your CI.
So if you invest a lot of work in the appearance of your product, you can protect it with a design. A registered design, provided that it's new, grants a time-limited monopoly on the appearance, that is the external shape and color design of a product. This could be, for example, clothing, furniture, or industrial designs. You can also register parts of products, registered design. For example, the sole of a sports shoe or the cap of a riding instrument.
Another series of work products may be protected by copyright. Copyright protects the original intellectual creation of a person. We all are familiar with this in the field of, let's say, literature, music, or film art. But there are also intellectual creations in the field of innovative work. This could be, for example, a construction plan, a database, or the source code of a software. Original intellectual creation means that a certain creative effort is required to create copyright protection.
Being not only in the creative business, but also in a tech environment, finally, patents will be of particular interest. So in a nutshell, patents are always linked to technologies. They're seen as drivers of creativity and innovation, and they serve to secure unique selling propositions and competitive advantages. A patent is granted for inventions that are new, involve an inventive step, and are susceptible of industrial application. An invention can belong to any field of technology.
So now that we know what kind of IP there is, the next question is, what do I have to do to secure these IP rights? In many cases of industrial property protection, the registration principle applies, which means that you only acquire rights to the IP once you have received the registration. Although there are legal exceptions to this, it is important to note that in the event of a legal dispute, you usually have the advantage of registration, which is also much easier to prove. When it comes to trademarks, designs, and patents or utility models, you need to apply for it with the competent patent and trademark office. Usually you have three options. Like first, you can apply nationally in the country where your company is seated, within Europe or internationally. The rights will be granted for an initial period of time, which can be extended in some cases.
So copyright law is a major exception here. Copyright arises ex lege with the real act of creation. A formal act such as registration or application is not required. So depending on the applicable legal system you're in, copyright usually expires after some time. In Austria, that would be in general 70 years after the death of the creator. Since priority in registration is very easy to prove, in copyright you have to be all the more careful to secure it because you want to be able to prove that you were there first. So what is the best way to do that? The old school way to preserve evidence is to deposit a copy of the work or a reproduction with a lawyer or notary prior to publication. Also, there are more modern ways of IP rights management, such as the evidence storage via the blockchain, for example. If you're dealing with the protection of copyright of a design registration is also a good and cheap tool to prove creatorship.
So whatever you decide, according to our experience, it is worth to always consider 3 principles when planning your IP strategy. So always remember, first come, first serve. Keep in mind that priority and its proof always plays an important role in the event of a dispute. Therefore, if you have executed a good idea in the form of a product, time is of the essence, especially in such cases where the value of the product depends on the rights to this product. Recommend to deal with the IP securing as early as possible. Think, for example, of the costs that arise when a startup spends a lot of money on its branding and marketing and then has to change it because it hasn't secured the trademark rights which are claimed by third parties.
The second principle is know your market. Developing a strategy in securing IP costs time and money. IP protection is also geographically limited. So the scope of, let's say, trademarks protection won't be worldwide, but always limited. Also, the cost of securing will depend on the geographic limitation. The more countries you want to secure your rights in, the more expensive it will get. It therefore pays off to also consider in advance which markets you want to conquer, let's say within the next 5 years, in order to specifically invest in IP rights there.
So the third principle is do your research. Keep in mind that in many cases can be prosecuted regardless of fault. This means that you could develop a product in good faith that someone else has already partially protected. In these cases, if the area of protection overlaps with your market, your company and the product are exposed to the risk of legal infringement. It therefore also makes sense to deal with the pre-existing IP rights, be it within the framework of your business plan or internal strategy.
Questions you might ask yourself are, for example, is there already a company in the sector that has a similar logo, trademark, or CI? What is the state of the art in the area I want to innovate technically? Or do I want to enter a particularly challenging market where also securing my IP will probably be more difficult? So the next step is to not only think about your external strategy, but also to think about what you have to consider within your company. In many cases, intellectual property such as copyright or a patentable invention is not created by just one person, but the collaboration of several people. This can be the co-founders, the employees, or even external persons who are commissioned for partial work. It's getting complicated when all of these people have partial rights to the intellectual property they helped creating. So although there might be legal provisions governing the rights between the inventor or creator and the employing company, as it would be the case, for example, in Austrian patent or copyright law, they usually do not cover all possibilities. So it is therefore also advisable to think about who should have which rights to the IP from the beginning and secure these legal positions also internally by transparent agreement. And what problems may arise in this context?
Think, for example, of a freelance developer of a source code hired by your company who sets up a competing company with colleagues. Or think of a dispute between co-founders of a startup who are also co-creators. One of them leaves the company and makes life difficult for the others by asserting his rights. But now that we have a first overview, an important question for how a startup could be, when do I need a patent? Patents are granted for inventions that are new, involve an inventive step, and are susceptible of industrial application. An invention can belong to any field of technology whereby a distinction is made between products and processes. A product patent protects all objects, such as machines or part of it, circuits and medicines. A process patent protects the processes used to manufacture a product.
So what's new? An invention is considered new if it does not belong to the state of the art. The state of the art is everything that has been made available to the public by written or oral description, by use, or in any other way, anywhere in the world. So this is very important. It's worldwide. And before the filing date or priority date. So therefore, one of the most important rules when it comes to patents is first register, then publish. An invention is further considered to involve an inventive step if it is not obvious to a person skilled in the art. The inventive step requirement is intended to prevent the normal, everyday, routine development of technology from being restricted by exclusive rights.
Patent applications are much more time-consuming and cost-intensive than securing other rights, such as trademarks or designs. It can take around 1.5 to 3 years from the date of application to the granting of the patent. The maximum duration of a patent is 20 years from the filing date. This is based on the idea that a patent is a territorially and a temporally limited exclusive right and should be available for the public after expiration. The patent application is, for instance, in Austria and the European Union, only published after the expiration of 18 months from the filing date. So your invention won't be published immediately. If you're working on a product process that could meet these criteria, we recommend to get in touch with a competent patent attorney as soon as possible, at the latest before publication. Make sure that the patent attorney is trained in the relevant field, for example, as an engineer or chemist.
So what about software? The principle here is software is not considered an invention according to patent law if it is claimed as such. However, a computer program does not fall under this prohibition if, when run on a computer, it produces a further technical effect which goes beyond the normal physical interaction between the program, the software, and the computer hardware. This further effect could be the case if, for example, the program serves to control a technical process or determines the functioning of a technical device. So again, it is generally not possible to patent software unless it is part of a patentable product or process. I'd say in actual practice, the protection of software from copyright law plays a much greater role.
So why would I spend a lot of money for this? It's relatively easy. Yeah? I mean, it's always keep in mind that protection of important IP rights, especially in the startup sector, can be attractive to investors or even a requirement for approval of investments. Also, you do not want to fight a battle over IP rights. That can really take a long time and is really cost intensive. Of course, it's important to distinguish which rights are relevant for you and for your company and do your research in advance. I think Julia is going to say something at the end regarding open source content.
Yeah, I would like to squeeze in a last question we prepared. That is, what if I want to use open source content in order to develop my product? I'm going to be quick. So it may be the case that you need licenses to pre-existing rights because of a component of your product is already protected by copyright. In addition to the licensing of components against payment, you could also have the special case of open source. Open source content would be released royalty-free under a license with specific conditions. You may know the GNU General Public License, which is the best known open source license. So open source hardware would be hardware manufactured according to free blueprints, whereas open source software provides the source code free of charge. If you consider using open source hardware or software, the key takeaway is to always check the license under which the description of the hardware or the source code is made available and to foresee the consequences that come along with it. since there are so-called copyleft clauses that oblige you to make the content available free of charge as well, there may be problems with the commercial exploitation of your product against payment. So keep that in mind also.
Okay.
Thank you.
Cool. Julia, Christiane, thank you very much. We had one question, but I think we ran out of time. Or maybe very quickly you can answer that. A startup might have a trade-off, right? Not to publish a patent and not to apply for it, because it might not have the money then to protect it, right? Because there's a big corporate can come and say, look, there's a patent, but we're going to fight against it, and he has not the money for it, then it's gone. And we might even end up selling that patent to that big corporate. So what is your opinion on that? Is there a trade-off sometimes not to publish something and to keep it protected rather than applying for a patent? Quick answer, please.
Yeah, so I would say rather apply for the patent, because the patent will not be published before 18 months after the application. So when you are in doubt, or if the money is not, if you don't have enough money, you may also want to consider applying for a utility model, which is a bit more cheap, yeah, more or less cheaper, and will also provide you some kind of protection at the first stage of your company development.
Cool.
But,
okay.
Yeah,
okay.
Yeah.
Thank you very much. We have to go on because we are a bit under time pressure, and the other Julia is really giving me bad signals. So I'll pass on directly to Julia. Thank you very much for your insights. Thank you.
Thanks a lot.
Thank you.